Good afternoon and welcome to the first webinar in our opioid webinar series with the Transforming Clinical Practice Initiative here at the Iowa Healthcare Collaborative. We do have some basic things that we need to go through just to talk through our continuing education pieces. So we'll go through that first before we get started. First and foremost, there are no financial conflicts to report for this webinar for any of the planning committee members or our speakers today. To obtain nursing contact hours, you must have entered your nursing license number at registration. You must be logged in individually with a unique email address for the entire duration of the presentation today. There is no partial credit given for nursing contact hours. A nursing contact hour certificate will be emailed to you following the webinar. It may take up to a week to do so. And then we'll kind of dive in here. I do have a couple of things that we'll talk about regarding continuing pharmacy education. Our pharmacy credit is available for this webinar. CE is accredited by the Accreditation Council for Pharmacy Education as a provider of continuing pharmacy education, and we'll provide the code at the end of the webinar. We also have continuing medical education offered. It's relevant to the conflict of interest we already shared, and you must be logged in individually with a unique email address to the webinar for the full duration of the presentation. A CME certificate will be emailed to you. For all other attendees, a certificate of attendance will be emailed after the webinar, and you will need to fill out an evaluation to get that certificate. And with that, I'll introduce our speakers. We have Craig Sieverding with us. He is a shareholder at the Davis Brown Law Firm in Des Moines, where he practices exclusively in the area of health law. He counsels healthcare providers on a variety of regulatory and compliance issues, government investigations, and contracting, and reimbursement matters, including those related to prescription and diversion of controlled substances. We also have Adam Zenner with us. He is a partner at Griffey & Sidney's Trial Division. His practice focuses on complex civil litigation, white-collar criminal defenses, trial work, and appellate practice. He has litigated all manner of cases and secured over 20 trial verdicts for his clients in the state and federal courts. He has also successfully litigated more than 10 appeals in the United States Court of Appeals with the 8th Circuit and Iowa's appellate courts. He's a fellow of the Iowa Academy of Trial Lawyers. And with that, I'll turn it over to Craig and Adam.
Okay, thank you very much, Sarah. I appreciate it. As Sarah touched on, both Adam and I practice in an intersecting area of health law and risk management and litigation. And both of us, Adam, and I think I can speak for you on this, have had more and more experiences over the last year or two on dealing with opioid issues, primarily from provider liability, but that kind of touches on other issues too when you start getting into personal injury and so on. Do you agree there, Adam?
Absolutely, Craig, absolutely. And this is a nice opportunity for Craig and I to visit with you all about the learning objectives that we've got for the opioid standard of care and litigation presentation here. Craig, do you want to take them through those?
Sure, you bet. I mean, so we'll talk first about the epidemic itself. It kind of frames where we are today from a risk management and liability and sort of where we've come from too, as far as the changes we're experiencing today. Then we'll talk generally about liability. There's probably some on this webinar who are more familiar with different types of liability than others, but in a lot of these situations that come before Adam and I with respect to opioid prescriptions and allegations of use and abuse, there's overlapping levels of liability. I mean, so we get the criminal, civil, administrative, and other. As lawyers, we kind of work through those and work with clients, but if you're used to liability in a general sense, it'll help to sort of separate some of that out. We'll talk briefly about underprescribing. It's more of a historical artifact, but it gives, I think it serves two purposes. One, it kind of shows you that pendulum swing from concerns on underprescribing to now concerns on overprescribing in the provider community. And two, it kind of paints a picture for providers as far as a difficult landscape they're in, that they have these obligations, but if they lean too far one way or the other with respect to prescribing practices, there's the potential of liability, litigation, and other issues. And we'll talk briefly about recommendations for risk management. I mean, both Adam and I are lawyers. We're not clinical practitioners, but we see from a risk management perspective some good practices, particularly in this current environment of new regulation and new enforcement on prescribing practices. So talk about the epidemic first, and I usually try and talk about this in threefold, mainly to try and convey, particularly to a provider audience, why there's such a heightened scrutiny and concern with how providers are going about the prescription of controlled substances, and specifically opioids. I mean, these prescriptions are provided, they're needed for such a wide variety of patient population. They do good. Providers have prescribed them for years. So a lot of providers that I've talked to have a hard time understanding why they think they're being singled out or focused on. And I just want to take you through this threefold. We'll talk about the increase of prescriptions, and we'll talk about access, and we'll talk about harm, because that's how regulatory bodies are looking at it, whether it's licensing boards, whether it's on a public policy front, legislatures, state and federal. They've sort of looked through this and track it back, not it in the singular sense, but a significant factor in this epidemic is the prescription or prescription medication. So we'll start with increase of prescriptions. There's great data out there from the CDC and otherwise, and it just helps to sort of put a finer point here. If you look at prescription opioids sold to hospitals, you're talking about a fourfold increase into 2010, but a lot of what people say is the epidemic has come after that. If you look at 2012, you're looking at providers writing prescriptions, 30-day supply for every adult. That's a nationwide statistic. There's good data out there as well on how that breaks down on the state level. Some states have higher prescribing than others. And one of the concerns has been that there's been no increase in reported pain, at least according to some scientific or peer-reviewed journals. Adam and I are in Iowa, and we know there's people on the call from Iowa and elsewhere. If you look at Iowa and you look at prescribing habits, there's been kind of a similar trend. And the Iowa Department of Public Health puts out this data, and it's regularly available. But in Iowa, at least, there's been a 100% increase in Schedule II prescriptions from 2011 to 2016. So that's significant. If you look at starting in 16, though, there's been a little bit of a flattening in the trend. I think some of what Adam and I are talking about today, as far as different regulation, renewed focus on enforcement of regulation, a lot of that has been happening over the last year or two. So you're seeing some practices curtailing a little bit, and it's also, I haven't seen data on 18, but I suspect we'll see a flattening for 18 as well.
Craig, one of the things, maybe I hop in here, one of the things that I think the literature has tried to figure out is what's responsible for that increase, and I'm not sure the literature is all too well settled on that. Most of the literature points to opioids having, of course, as you've mentioned, long been used to treat different types of pain, but primarily it was acute pain, cancer-related pain, that sort of thing. I think in about 70% of the studies that have been done showing the efficacy of opioid-related treatments, they are what we would consider short-term. As you mentioned, Craig, you and I are here in Iowa. The Iowa Administrative Code defines short-term pain, or that is non-chronic pain, as something less than 90 days. In any event, I think the literature would suggest that the increase in these opioids being prescribed is a result of providers finding efficacy for the chronic pain. And that, among other things, I think the literature would suggest is the reason for this increase.
That's a fair point. That also gets to the perception, and a very fair one, of sort of this focus on providers and where providers are coming from, as they historically always have been, and that is treating the issue in front of them and doing it in the most effective manner, and the literature has supported that as well. A little illustration here on the slide in front of you is just as far as consumption of opioid prescriptions. over a 3-year period. And that's probably not surprising to many in the audience based on what we've heard. I think where a lot of law enforcement, at least, where their ears perk up and what they get interested in on prescriptions in particular, they're not going to dive into it and necessarily understand the clinical piece so much. They look at it as an access piece in the community and how that leads to abuse, so outside of prescriptions. And there's been studies out there that have done to show that a lot of prescription medicine that's being abused is actually not really coming from what people would think of as a conventional or typical or caricature of a drug dealer. It ends up being more from family members who are getting it, getting 30-day supplies and not using them, or family members who are getting them under false pretenses from their providers too, as far as misrepresentation of their condition. So that's sort of the pivot here, and I think what really helps some providers understand and see why is there this renewed focus, why are they changing standards of care or trying to change them, and sort of to try and curb this, because that's really the turn in the road and how we get from prescriptions to more of an epidemic.
Greg, can I hop in there as well? And this is just nomenclature that I found effective or helpful in the literature that these slides talk about. I think for at least for me, maybe I could at least provide that perspective. But for me, the literature makes sense when it talks about one concept, which is abuse, which is what Craig has indicated. Another concept in the literature is misuse. And if I could just put a finer point on that, the misuse really focuses on the patient and the patient's own, whether the patient is following the doctor's orders, essentially. Are they taking more than what the doctor's script provided? Are they taking less? Are they taking that in combination with perhaps a different drug? That would be misuse if the patient is taking the medication other than as prescribed. The abuse, as Craig's indicated, is really, that's really become a large problem as well for providers, because that abuse really is more closely associated with non-medical use, and obviously outside the physician-patient relationship. That can include diversion and things like that. So anyway, those two concepts, I think, are a nice rubric or matrix for us as we continue to look at this.
And so moving on, I mean, the concern has really got everybody moving is sort of the harm in the community, and that's been documented in every state in the country on one level or another, certainly federal with the CDC. But some of these statistics are, they jump out at you, and those are the statistics that are up at state legislators in Iowa. We've seen the talking points from people who are looking at really trying to enact some meaningful legislation, ones that have significant changes. I'll just pull a few out, the rest will be on the screen, but you look at since 1999, overdose deaths have quadrupled. In 2015, you're looking at 33,000 deaths in the United States, the most of any year in record, and I think in 16 it may even have passed car accidents. To some degree that has abated, and I think early literature is suggesting that that trend is leveling out a little bit, in part due to the availability of naloxone and other treatment sort of stem the fatal impact of an opioid overdose. Again, in looking in Iowa, some of those statistics are similar. If you look at treatment admissions for opioid, it went from 608 in 2005 to 2,200 in 2016. So that's 2.5, 3 times increase as far as deaths and overdose-related deaths. That's gone from 59 in 2005 to 201 in 2017. So that's a significant increase as well. And again, that's what's gathering the attention here in the public health and the law enforcement, the nonprofit social services, and the healthcare provider communities. And this is just a point, and Adam, maybe you can speak to this a little bit, but when we talk about harm with respect to opioid misuse and abuse, it's far more than just the final statistic of deaths. It's the treatment costs on admissions, it's the collateral consequences with families, children, communities, and it's also, of course, on the individual as well. Adam, you've dealt with this. It's far more than dependence is far more than just a potential risk of abuse and overdose.
Yeah, and Craig, I think this slide that we put together does a nice job of just illustrating what some of those risks are for that need to be counterbalanced by the provider. Noteworthy, and you and I were talking about this, but noteworthy, one of the things that's not on the slide or not highlighted specifically, or maybe to the degree that it should be, but under behavioral is the addiction. And this is something that I think we're just learning more and more about. As you and I were talking, the American Society of Addiction Medicine defines addiction as, quote, a primary chronic disease of the brain, reward, motivation, memory, and related circuitry. So that's maybe a starting point, but appreciating that opioid dependence can lead to addiction is something that our providers, is something else that's at the provider's feet that they need to contend with and need to appreciate.
Yeah, and I think we'll get to that in a little bit, that addiction in and of itself is a harm as a legal concept, such that there's liability for prescribing practices that lead to that harm from a causation element. This is just some more of the numbers, the slide in front of everybody, with respect to at least 2016 with CDC, capturing much of what we've done. And we've seen, this has been declared a public health emergency. That was just about a year ago, and that freed up federal funding. And it's kind of what I want to get to and sort of turn a little bit here to a different topic, and that is, with this epidemic, with the recognition, I think, on many different levels in many different areas, that there's this connection to prescription. You have almost everyone involved trying to do something about it. And, that's a human response. It's a public response as well. But you have legislators, they're passing sometimes soft enactments about we're going to do stuff. Sometimes it has to do with freeing up money, as with the feds and determining it's a public health emergency. Other times it's passing more definitive or detailed legislation. And providers have obviously thought, including through Iowa Healthcare Collaborative, and what's the best practices, how do we collaborate, get on top of this. So the responses are everywhere, and the response that I think Adam and I are most able to talk about is the response that's also coming through the legal community. And part of that is the new laws and regulations in effect at the federal and state level, and new enforcement. And we certainly see that from our vantage point as lawyers who help out providers. And something we want to touch on today that, I think providers really have to be attuned to, and that is evolving standards of care. And we'll get to that, but, undergirding any liability, and we'll talk about these next, whether it's civil, criminal, or administrative, is what's the standard of care? What's the reasonable and rational approach versus our talk for prescribing practices? And with this epidemic, we have both sort of seen that change. What we've heard law enforcement officials tell us, what we've heard licensing board investigators and staff tell us, what we've heard plaintiffs, counsel tell us, and potential cases or actual cases are different today than what it was yesterday. And that's natural in one sense because standards of care evolve over time. But what we're experiencing here is that evolution in the back, not just with the backdrop of the epidemic, but the epidemic kind of forcing it along, probably a higher pace than what you typically see. We talk about medical standards of care and how they evolve. So, talk a little bit. So, we're going to talk generally on this again. Some of the listeners on the call are going to be pretty familiar with different types of legal liability and parsing amounts, but we kind of want to go through them quickly so people have it in mind when we're talking about it today, or when you're dealing with any of these issues. Because if you get a diversion issue in the workplace, someone's taking medication for personal use and denying that medication to a patient, you've got to be thinking about all three of these. So briefly, and maybe you want to go through some of these, Adam. You're pretty familiar with these.
Sure, happy to. These civil liability to start. That's what everybody is familiar with from a medical malpractice standpoint, and that's provider liability. It's also what I call organizational liability. Oftentimes, in these medical malpractice cases, plaintiff lawyers will sue not just the provider, but also the institution that they're practicing on in combination with. The False Claims Act, notably, some people are less familiar with this. Craig and I deal with this a lot. False Claims Act, of course, deals with improper billings to generally it'll be a governmental entity, and oftentimes they're fraudulent billings for services not rendered or upcoding, that sort of thing. The False Claims Act has significant remedies for that include treble damages and potentially punitive damages as well. That's kind of our civil liability front. There's often insurances that can help to serve those deficiencies. The False Claims Act not as much, but that's civil liability in a nutshell.
And I guess where some of those billing issues would come in is on a diversion case. If someone's taking medication, that's either part of a bundled payment, which is going to be made by a governmental program or a commercial insurer, or it's going to be a separate fee for service for that medication and/or the dispensing fee. If in actuality that drug was actually never conveyed or provided or administered to the patient, there's got to be an examination on behalf of the entity of the extent of that so they can correct those previous submissions to the payers. We talked a little bit about standard care before, and here's a slide for it again. It's a reasonableness standard, but it's based on prevailing professional norms regarding whatever the practice is. So, again, that undergirds not just civil liability, but as we get to it, criminal liability and administrative as well. So, I should go back. I mean, just so people know, the standard of care isn't something that frankly, attorneys or providers agree upon, or anyone can look at one source to find out. It ends up being an exercise in the context of any legal issues, trying to divine what the standard of care is. And sometimes it's more clearly defined depending on the situation than others. With respect to prescribing, you're pulling a lot of information, what the federal government's expecting, the CDC, what the state authorities are expecting, what state statutes are indicating, but also what the community says, so what providers in the community say. And more providers are coalescing around a standard that resembles more what the CDC has put out in 2016 than for what understandings were, say, 10 years ago. Criminal liability, Adam?
Yeah, criminal liability. This is the Controlled Substances Act from the federal standpoint. There's also, of course, state statutes relative to diversion and controlled substances. That is, we see that a lot. In fact, and I think we've got a slide later on with a provider. This is all public information. Provider out of Newton, Dr. Twiner. He was convicted by his own guilty plea of diversion under 841, which is the Controlled Substances Act, the federal act sometimes the shorthand 841. That has significant penalties. Now, actually, under this current administration, we're seeing mandatory minimums, 5 years mandatory minimum. Obviously, if the distribution causes death, that is, say a prescriber provided a substance without a prescription, and the person who took that opioid then died, there would be a 20-year mandatory minimum. And that's the sort of negligent homicide that's referred to in our slide. There's also, I was involved in a case where a doctor was charged under a state statute for what we'd call, involuntary manslaughter, what amounts to recklessness, simply based on the provider's, prescribing practices, and the lawsuit was unsuccessful against the provider. But as Craig and my slides point out, that's certainly a risk that providers now need to confront. Prior to that case, which I think was prosecuted in 2013, there had not been a similar type of charge, at least in the state of Iowa. Those are kind of my limited thoughts on criminal liability.
That's great, Adam. And so administrative liability, talk about civil, criminal. Administrative is, almost a catch-all term dealing with state agencies other than law enforcement who would go a criminal route. So licensing, drug enforcement, exclusion. And so these are sort of boxes to tick if, quality control or risk management have an issue, say with diversion, or even alleged overprescribing, a complaint coming from the outside as far as where potential liability is and what needs to be addressed. Because particularly on the administrative level, there's a lot of mandatory reporting in place when you start getting into the weeds and some of diversion and other types of cases. But that's probably for an entirely different webinar. So
a practice point would be, I'm sorry, Craig, but a practice point might be, at least as I read the administrative code, we have provider obligations. If your provider is aware of improper activities along the lines that Craig has identified, obviously opioid abuse, diversion, that sort of thing, by there is a self-referral or referral requirement under the code, and you'd have 30 days from the date that provider learned of that information to make that report to at least the Iowa Board of Medicine. Of course, if your providers falls within that ambit, I think it's the same 30-day requirement for nurse practitioners, et cetera. But in order to insulate themselves from other liability, you obviously need to get that reported to the appropriate board.
That's exactly right. At least in Iowa and other states do have comparable referral requirements as far as referring on similarly situated licensees, so same licensing authority, and known or suspected violations of the regulations. Other liability, real quick, privileging, peer review, employment, and so on. I mean, there's a lot of downstream tangential consequences to any issue involving overprescribing, diversion, and so on. So with that little intro into liability, I want to talk about underprescription and then overprescription. And again, at the outset, I spoke of underprescription briefly, and some on the webinar probably interested just to see underprescription here, because it hasn't been the focus. Again, I think the two takeaways with it, and good to help put the rest of the conversation in context, is just shows you the pendulum swing we've had here in the provider and risk management and legal community over the last 20, 30 years. And also, it conveys what is a real sense that, prescribing today is somewhat of a rock and a hard place situation, that there's serious health issues and pain, chronic pain or acute, to address. We have very efficient medication, but that medication has a potential for addiction and how to thread that needle, so to speak, between under and over prescribing.
Craig, on this, may I
Yeah,
have in here? I think where we see, or where, and I trust where Craig sees this too a lot, but where at least I see a lot of this under prescribing, it happens in two places. One, because a patient says, my pain is not being adequately controlled. Of course, we're there. But it also really comes up with now the termination of patients. What you have is a patient says, I've improperly been terminated from care, oftentimes because of misuse or suspected misuse or diversion or whatever. And what Craig and I were talking about earlier is, before we got on the call, Craig is very familiar with the standards of practice for appropriate pain management in the Iowa Administrative Code. It's 653-13.2, and it's actually sub 6 that says, quote, inappropriate pain management may include non-treatment, under-treatment, among obviously over-treatment of pain. And so it's just, at least as far as the Iowa Medical Board is concerned, and what our standard of practice is generally, it's just as serious, at least purportedly, of a problem for providers to undertreat pain as to overtreat it. And as Craig talked about earlier, this is my phrase, but that's the sort of pickle, or maybe what Craig said, the rock and the hard place that a provider's in, because if we suspect some of this abuse or diversion, how do we resolve that? Because if we terminate too soon or inappropriately, then that too is a violation of the standard of care, at least as it's laid out within the administrative code.
Yeah, thanks, Adam. And I'd add the third scenario where I think we've seen this underprescribing pop up recently. Again, it's not so much an issue as it was 20, 30 years ago, is with what could probably be described in some degree as defensive medicine and hesitancy to prescribe, particularly in nursing facilities, and particularly in nursing facilities and dementia care units, when sometimes there's a challenge in actually having a full understanding of the patient's level of pain. There's been some studies to suggest that there's been an increase in underprescribing in those arenas over the past several years. So that's the Iowa Board of Medicine on the slide in front of us that Adam just referred to. Civil liability, again, these cases are almost 30 and 20 years old, but this was kind of at the high point in the early and late mid-90s as far as the emphasis under prescribing, and just puts a kind of a legal endpoint as far as a judgment, settlement, or verdict on this issue. But I want to spend a little bit more time, because what providers are more likely to experience with underprescribing, it's not so much underprescribing, it's actual undertreatment, and that has to do with diversion. It's one of the more complicated issues that come up with providers, because usually diversion ends up being criminal, so you get that criminal level of liability, and it invokes a host of civil and administrative liability, but it also raises employment issues. I mean, we get questions all the time in the wake of these, can we drug screen and so on. So it raises a whole host of issues, and it's a more common scenario. So we talked about diversion a little bit. This is the transfer of a prescribed substance from the individual to whom it was prescribed for another person for any illicit use. And for healthcare providers, this is usually employees or independent contractors who have access to this medication and or quote unquote diverting it or keeping it from being administered to the patient. So, and it's a typical scenario is they're diverting and does not receive an undertreatment. And there's have on a slide here the civil liability of medical negligence, battery, and more, but there's a whole host of other liability here, including, and sometimes it's not always foreseen, but if the method of diversion is actually extracting out the controlled substance from a IV bag or from a vial, and then it's saline or some other substance is reinserted into those vessels, you get adulteration of substances and really tricky and difficult scenarios with which how you have to work through reporting this to individuals that they may have received an adulterated substance, questions of whether you offer testing and free blood testing and so on. So that's a typical scenario they wanted to highlight as far as undertreatment. It didn't really fit into underprescribing, but it certainly doesn't fit into overprescribing, but it ends up being one of the highest liability areas for a provider. So we're going to spend kind of the rest of the time, other than a wrap up on best practices on overprescribing. And as Adam has touched on, there's this duty, of course, to provide appropriate pain management, and overprescribing of opioids may cause harm, as a lot of literature and a lot of the data has shown, whether it's addiction or other injury. And again, one of the reasons we're talking, and we've talked to providers, is because in the legal community, from a law enforcement perspective, overprescribing leads to access, which then leads to sort of the public and community harm. So we'll talk about a few areas, how these come up and how they've changed over the past several years. One is liability to third parties. So these are situations where there's a prescription to an individual, and due to alleged overprescribing, for example, prescribing to an individual who's known to abuse or is currently abusing, or prescribing in numbers that provide that individual with access for more or greater number of controlled substances than they may need to control their pain. One of the potential liability points would be for third parties. So this could be, the examples put up here, one of the classic ones is a patient who's driving in a car. And this is a fact pattern that's probably always been out there for lawyers, particularly the work you do, Adam. I'm doing a lot of work defending providers and other employers and companies who have had an employee cause an accident, whether due to drinking at the job or otherwise. That's always been a fact pattern out there, but now you're seeing it being raised more. You're seeing the plaintiffs bar being more interested in this. And I guess you can add to this, Adam, but I kind of see that twofold as standards are increasing, an increasing number of providers are arguably or allegedly below those standards. And two, just the jury pool has changed a bit. And the public has been inundated with how this is a crisis and how everyone's got to contribute. And you can be portrayed in a courtroom as far as being on the other side of that effort. Plaintiff's counsel, someone representing an injured victim, could see that as an opportunity to convey and push their case.
Absolutely, Craig. And we have seen it. You talk about this typical fact pattern or lawful, what you and I would have seen many, many years ago, unfortunately now, as a law school fact pattern. We have seen plaintiff lawyers sue and bring in, of course, if for example, there was an accident up on 380, the driver was test positive for opioids in the driver's system. The driver said, look, I was taking this, yeah, of course I tested positive, but I was taking this pursuant to doctor's orders. The plaintiff lawyer said, oh, not so, because you would have been in this particular therapeutic level. And the defense used by the driver defendant was, well, I don't know what to tell you about therapeutic levels. I can just tell you this is how I was supposed to take them. So the plaintiff lawyer then sues in the doctor as well, as you're talking about potential liability for inappropriate prescribing. If the person was taking the script as prescribed, then
It's the
then it's the
prescriber's fault.
prescriber's fault, because they've related that distracted driving or inattentive driving to that. So there is, as you indicate, there's just a host of new wrinkles on what used to be old type fact patterns, particularly with this evolving standard of care.
It's part of a trend of seeing not just the prescribing, but the manufacturer of controlled substances, and then down to the prescriber, sort of when there's injuries in the community and there's potential legal claims, that those claims are looking more upstream, so to speak, than they have been. And in Iowa and in other states, attorneys generals are actually going after the source as far as suing the manufacturers who are promoting these or marketing them, and how those marketing efforts have, to prescribers as well as to the public, led to an increase as well. So I know in Iowa, a lot of counties are also suing in order to get coverage for emergency medical services and cost of naloxone treatment and so on. So it's part of a larger trend, but unfortunately providers and prescribers are part of that as well. Here's just two fact patterns that you'd see. I mean, and again, one's from 2007, so these are kind of always been there, but you're just seeing more of them. Provision of methadone to a patient who injected himself in the drive home, causing an accident. And, you know, again, the fact pattern that legally probably could have been brought many years ago. You're just seeing it more and more due to some of the reasons we've discussed. I want to move to another harm. I mean, one harm is sort of third parties, and another one to the individual, at least, is addiction. Adam, you had spoken a little bit when we had a slide up of sort of the impacts on an individual, the physiological impact on an individual with respect to opioid dependence. In this case, the harm is actually the addiction, right? And to quantify that, that would be the addiction leading to an inability to maintain a job, so the loss of economic income. It could also be the cost of treatment and so on. But you know, the liability matter, again, not unique, but seeing it being pushed and seeing it, at least in this case, successfully litigated.
Absolutely, and I think this is a really hard or difficult area. What I see in my practice and perhaps you see in yours is you have providers who are well-intentioned providers who medically, I think this is the rub that I've come across in my practice, medically, addiction is defined in a medical way.
Sure.
From a liability standpoint, the law defines an addict and in a little bit different way. That dependency from a provider standpoint is often looked at as obviously a medical condition that the provider needs to appreciate, accommodate, and continue to hopefully improve, as most well-intentioned providers would do. But sometimes there's a disconnect then with law enforcement who say, well, why are you providing this addict, for them, this person who is addicted, with a substance that they have an affinity for? And the provider's reaction is oftentimes because we're treating simply because they're an addict. Doesn't mean they don't have legitimate complaints of underlying pain. And so it's you get some providers, as you've indicated earlier, Craig, that feel sort of improperly singled out or hard done because certain pain providers are trying not to violate, tenet 6 of what we already talked about, which is we can't undertreat pain. And yet you have law enforcement saying, well, wait a minute, there's this issue of addiction And so it's just a really tough area that I think we're going to, need to continue to work through. Frankly, some of the guidance is not perfect, on that. I think the Iowa Administrative Code says, as you continue to see instances of misuse and diversion, you have to consider termination, but you just have to consider it. You don't necessarily have to terminate. And so anyway, that's one place where there is a particular rub here, and this notion of addiction, is just it's a really thorny area. I might just note at this juncture, one of the things that the literature suggests when providers, well-intentioned providers, are trying to give attention to this and make sure there's adherence, in addition to the UDS or urine drug screening and that sort of thing, there are some non-adherence patterns that the literature's identified, which is obtaining prescriptions from multiple providers. It's taking opioids without the physician's knowledge. Obviously, that's something the UDS will help with. Alcohol or illicit drug use, and escalating doses or requesting escalated doses of pain medications, obviously without permission. So
those are all red flags.
Yeah, those are all red flags, exactly.
Yeah. And I think we were talking about standard of care, and this is a good illustration of this, right? And we explained, if you ask standard of care is, people may describe that a little differently, and that difference may be valid across different communities or locations of practice, right? A specialty pain clinic in an urban area may have a different standard of practice than a rural community in Iowa or elsewhere. But, for lawyers like Adam and I, if there's a liability question at the end of the day, someone's got to decide what the standard of care is, and that's not a provider. It ends up being a jury or a judge. And one of the risks for providers is that the standard of care is moving in such a way that it's becoming more and more likely to be determined by that judge or a jury to be higher than what a provider thinks it is. And that's sort of where the liability exists. So in this case, very well-intentioned providers trying to do the right thing, adhering to a practice and policy that they've done for some time, but it became questioned, and unfortunately questioned in the court of law. And standard of care that carried the end of the day required certain specifics. I'm not sure if UDSs were on there, but certain specifics that wasn't part of that provider or that clinic's practices. Whether that's using a drug monitoring program, a prescription monitoring program, whether it is agreements, and we'll get to some of those when we talk about our recommendations, but this is really a good case in the illustration of a shifting standard of care. Injury, we've talked about addiction as a harm to an individual or a liability can manifest. Injury, and this is somewhat self-evident, but if an individual has a legally recognizable harm as far as addiction due to prescribing, they also have harms other than that that can somehow be traced as being causally related to a negligent prescription. So overdose is a classic one because that leads to pretty concrete harm in the legal sense, harm not in the causation sense. So overdoses, whether it's death, whether it's leading to brain injuries, or even somebody who overdoses and falls down a stair. Those injuries that result from that fall down the stair can also be part of a potential claim in a case. I'm going to talk about Gray versus Baldy. This is an Iowa case, and many of the listeners on the call in Iowa may remember this one, but this dealt with claims to the patient and wrongful death, I believe.
Absolutely, Craig. And I happen to have a unique perspective. I represented Dr. Baldy in his criminal case. This Gray claim that we have on the screen, this is actually the civil case that grew out of it. Essentially, the Gray is the estate. Paul Gray was the drummer for Slipknot, which is a band out of Des Moines. He overdosed on a couple different things. Fentanyl, I believe, and this is testing my memory now, we're about 5 years past, but his death, but I believe it was fentanyl, morphine. There was a script that Dr. Baldy had written that was in his system, although that was at a therapeutic level. The crux of the case is, was essentially what I referenced earlier. Well, wait a minute, was he an addict? Should you have continued to treat him, appreciating the addiction? That was really the basis of the criminal suit and ultimately the civil suit. Like I say, not guilty in the criminal case. I believe the civil suit was ultimately, it was gutted for procedural reasons. It was time barred as to the wife. It went up to the Supreme Court on whether his unborn child had a cause of action. The Supreme said he did. The unborn child would have had a cause of action, which would have been told past that 2-year limitations period. Went down. I believe it was resolved at that point.
So switching to criminal, we'll move a little quickly through this because cognizant of the time left. As Adam mentioned at the outset, it's the Controlled Substances Act, and it's interesting. It's the federal act that would get at someone manufacturing methamphetamine, and it's also the same act that gets at a provider who is allegedly overprescribing. The nuance or wrinkle there is with respect to providers, the regulations spell out that in a matter of federal criminal law, the prescription must be issued for 1, legitimate medical purpose, 2, a registered provider, and 3, within the usual course of business accepted standards of practice. So again, you get back to the same concept of standard of care, is whether the prescription was appropriate. Something to note, I don't want the listeners on the call to be concerned that there's the same degree of criminal exposure, civil exposure in every case. For one, the burden of proof is so much higher in a criminal case that criminal prosecution is usually reserved for select instances of alleged overprescribing. We'll get to that, quote, pill mill and other types of cases. And 2, prosecutors themselves, although prosecution of overprescribing or opioids in general are on their radar screen, and every U.S. Attorney's Office or state prosecutorial authority will say that in their discretion, they're also using it to go after sort of the rare and egregious cases. But there has been an increase. I mean, I think, before 3-4 years ago, there was one seminal case from 2010 when there was actually a criminal conviction of a physician or a prescriber with respect to the overprescription of pain medication. But just anecdotally, and this is just from the national reports, you're just seeing more and more of individual providers being charged. And again, they're being charged on pretty egregious circumstances. Again, not differences of opinion on prescribing practices, but more on diversion, kickbacks, things like that really just set them apart from standard clinic practice. Move a little bit through Iowa, but this has happened in Iowa as well as in the other states. I've been involved in cases because physicians have been licensed in Iowa where there's been prescriptions in Illinois, and providers in Illinois, Michigan, and so on. And again, this is an illustration of sort of the level of disconnect from standards of practice that would have to get to criminal liability. And it's a fact pattern, a general one, but it was pill mill prosecution where there's a provider there who's licensed, who's writing scripts, and it all looks fine. But if you look beneath the surface, the U.S. Attorney's Office or the DOJ we see that there's really not much of a physical examination. The prescriptions are far more than the 30 days. Sometimes there's other circumstances. Cash-only clinics stand out. Malleable provider prescriptions. So if a doctor or other provider writes a prescription and then is told to write a higher prescription and they follow through with that issue or that circumstance kind of raises this as well. And it's kind of part of a pattern of practice where some clinics has a model set up where there really isn't much oversight at all, and the interest is more on sort of getting patients in and out of the door with prescriptions. And those have been the focus, particularly federally, but also on a state level as well. Adam, I don't know if you have anything brief to add on that.
I think just due to the time, I think that's a great piece that you provide.
But a little bit on licensing boards. Obviously, there's the Iowa Board of Medicine, the Iowa Board of Nursing, PA Board. In Iowa, other states have similar licensing boards, and also the pharmacy boards. And through sort of those regulations, there's guidance as far as good prescribing habits and practices, and also the risk of enforcement. So, you know, at least in Iowa, the board has basically said if physicians are reasonable and responsible in how they're prescribing, we're not going to investigate. But again, what's reasonable 10 years ago is different than what's reasonable today. And Adam spoke of in Iowa where the appropriate pain management practices are, and they should check the boxes on a lot of what the CDC says as well, as far as having an evaluation, having a treatment plan, pain management agreement, patient history, including prescription monitoring program as well. And in Iowa, at least, there has been significant changes to the prescription monitoring program in 2018 through state legislation. Other states have moved toward this as well. And as I think many on the call should know, moving towards, at least with the legislation, mandatory registration, and we'll soon be seeing mandatory use once the licensing boards get through with their regulatory process. There's just some flavor as sort of the changes here. You're just seeing a 100, 200, 300% increase, at least with the Board of Medicine, on looking at prescribing practices. And it's not that prescribing practices has changed. I can tell you, at least for the 16 and 2017 discipline cases, of individuals who had pretty much had the same prescribing practices that they've had for 20, 30 years. The problem was that those practices haven't evolved or changed to the same degree and at the same pace as the board's interest and scrutiny on ensuring appropriate and well-circumscribed pain management practices. And enforcement in these cases, interestingly, it's not just censure and fines, which are kind of garden variety discipline, but almost all of them come out with a requirement, a restriction on practice that the individual cannot prescribe controlled substances to patients, at least for chronic pain. You can still do it acute, emergency room, or other setting, but those should be short supply and no longer for chronic pain. And another issue in another webinar, Adam, is how that has changed the landscape as far as access to care for individuals in rural communities who have chronic pain issues. So. DEA, just a flag, they, like every other enforcement authority, has seen an uptick on it. So I just want to move quickly to sort of recommendations, because that was one of the topics we wanted to cover. And we've gone through sort of the sources of liability, and you just got to understand how those come up, creep up, because compliance generally is about preventing. If you don't prevent, detecting, and if you do detect, or if you don't, respond when you learn of it, right? So you just got to have in mind sort of the different potential areas of liability, because that shows you potential exposure, but it also shows you who you have to talk to and address, whether it's licensing boards or otherwise. The other big one is just having a plan on prescribing. I think clinics that have protocols in place, even if they're somewhat loose, to appropriately allow for independent professional judgment is a good practice to have. And it's once you have that in place, it's about looking for red flags. And Adam touched about some of these as far as UDS, urine drug screens. But these are the ones that come up in the fact patterns on the federal investigations we've been involved on, state and licensing board as well. So high doses, inordinate quantities, total prescriptions relative to other prescribers. Very interesting because at least in Iowa, prescribers starting in 2019 are going to see where they stand with respect to their community as far as if they're an outlier. And from Adam and I's perspective, that's one of the great grievances we have is sometimes the information out there is with the government and it's not really shared, and small problems could remain small if providers are told early that there could be a potential issue. Inconsistent timing if people are coming back early. Other issues, there's physical examinations, lack of personal contact. Sometimes it's easy to get phone call refills, but sometimes with opioids, it's not the best practice. And also prescription monitoring program as well, as far as indications that the patients are receiving similar or overlapping prescriptions from other providers in the community. So with that, it's about having that protocol. You know, the recommendation I usually give is in the clinic after a physical exam, document with informed consent, and then manage those red flags as they come up. I think with that, we're pretty close to the end. Just the CDC guidelines, they're 2 years old now, but they're really having a gravitational effect on what state licensing boards are doing, where standards of care are moving to as well. So I think that's about it that we have, Sarah. I don't know if you have some wrap up of some questions to address.
Yeah, absolutely. And if anybody has a question, feel free to type that into your chat box and we can take a couple of those quickly here if I have any come in. So feel free to do that as I go through this other information. We do have some upcoming events. We've got our opioid webinar series that continues. This is our first. It'll be every 2 weeks at noon on August 15th, 29th, and September 12th. We also have the Nebraska PTN Learning Community on August 8th, and then our annual conference, start looking for that on November 7th. This is just showing our different topics that we'll be touching on. So our next webinar will be August 15th, and it'll discuss identifying and treating opioid use disorder. We have a nurse-physician team that will be presenting on that, and they have a really great presentation on medication-assisted treatment. Again, to obtain CPE credit for this webinar, you just need to fill in your CE guide, kind of go to this website, and then there's a way that you just type in your code. That does have to be done by the end of the month. Here's the website. So you just click on that, and then our code for today is capital E, lowercase k, 6, lowercase s, 8. So just take that to the CPE website and you can get that credit. For CME, we do have for both DO and MD available. So there's instructions here on how to do that. Again, there's no conflicts of interest, and you must be logged in individually with a unique email address to the webinar for the full duration of the presentation to receive that credit. Other healthcare professionals, you can also receive 1 hour of AMA PRA category credit if you're interested, and certificates will go out at the end of this week or early next week. With nursing, you must be logged in for the entire time with an individual and unique email address, and again, certificates will be emailed out following the webinar. And then my contact information, as well as Ellen and Nikki's, is here. Ellen and Nikki and I are the planning team for this webinar, so feel free to reach out with any questions or if you would like additional information on this topic. And I have not seen anything come through the chat, so we'll leave it at that. If you do have any questions, feel free to reach out to me, and I can get those to Craig and Adam. I do want to thank you both for being here today. It's such a great topic and something that I think everybody will be appreciative of on this.
Thank you, Sarah.
Thank you.
Thank you.